I can hear you.
Fantastic. Thank you so much. Appreciate that. Okay, so let's get started. Just to remind you, my name is Ivor Blumenthal, and the purpose of this particular webinar is to ask yourself the question, do we know what the tough employee decisions are that we're needing to consider? How do we manage performance after 6 weeks of lockdown? And importantly, after 6 weeks of our employees being temporarily laid off? And finally, how does Section 189 work now that we are either fully or partially back at work? Importantly, we know that prior to COVID, we were going through a massive economic downturn in South Africa. We know that on the precipice, on the cusp of COVID, that we had a downgrade to junk status by Moody's, and we've subsequently had another downgrade to junk status by Standards and Poor's. So we were in economic decline. Generally, it's accepted that most companies were in a Section 189 process. So what I want to examine in the third section of today's discussion is, how did COVID affect the Section 189 process? How do we pick up after COVID? And importantly, if we want to initiate a Section 189 process, which might culminate in retrenchments or some kind of severance of employment, how does that work given the interjection, if you want, of COVID? Again, please let me remind you, you're free to ask any questions you want to. Just unmute your microphone, and importantly, use the chat box facility and feature. I do want this webinar not to last for more than 45 minutes. The intention is to complete it by 2:45. However, should there be pressing questions, please don't hold back on those questions. Good. So let us then commence, ladies and gentlemen. Now, you'll see in front of you that there is a slide with something at the top that says that COVID-19 oversight guy. That COVID-19 oversight guy is the name of a Facebook page that has been set up to allow us to look at all of the issues and applications of the various regulations and laws by our various enforcement departments, such as Department of Employment and Labor, as well as other government departments. It is a site where we're able to ask questions. It's a site also on Facebook where you're able to post all of those very disturbing videos and maybe audio files you might have of exigencies by various government departments and government officials, things you're not aware of, things you're not comfortable with, and importantly, questions you might have that need to be answered. So please feel free. The very first question we had, by the way, was for those industrial companies out there that are receiving all of these massive bills, even though you've been closed down and your company has been in lockdown. These massive power bills from Gauteng power suppliers based on averages. And we're certainly endeavoring to get some answers on that and how you can be expected to pay those bills, number one, and whether or not you have any right of appeal in terms of the estimates that they've come up with. So that's just an example of, in fact, what's coming up on that site. So I say again, that COVID-19 oversight guy, please like the page, which will allow us to communicate more effectively and more efficiently with you, our followers on WhatsApp and our followers on various portals. Okay, so let's get to it. So let's talk about tough decisions, ladies and gentlemen, because ultimately, this webinar has to do with how we manage the most expensive, the most elaborate, and the most difficult resource within our workplace, which is the people who work for us. Let me start by just going over something that you should all know by now. If you have already opened, or if you're in the process of opening, then you will be aware of the 4-stage reintroduction upon opening, which is required in terms of regulation. Just let me very briefly tell you that those stages are, number one, where you would use a small skeleton staff to have your workplace readied in terms of your standard operating protocols, in terms of sanitization, in terms of social distancing, in terms of posters, and very, very importantly, in terms of a risk assessment you would conduct on the workplace, and critically important, how you would communicate with your employees before they come back to the workplace in terms of understanding the process, in terms of understanding the SOPs, to the extent that they are ready, that they're knowledgeable, and that they're informed. The Department of Employment and Labor have just recruited a whole lot of more, a larger number of inspectors that are going around. They've already done about 2,500 inspections of workplaces. They're going to be doing many, many more. And what they're going to want to see is your risk assessment, is your communication, your standard operating protocols, all of those things in place. There is a webinar we ran this morning on that. We will be posting that webinar to all of the groups. So I'm not going to spend too much time here, except to say stages 2, 3, and 4 are the reasons that I've included it in this slide. Because stages 2, 3, and 4 are about how you take your workforce, how you divide your workforce into 3 equal components in terms of numbers or in terms of divisions of your business. And then importantly, how you space out inviting those people back to the workplace on the understanding that until they're invited to come back to the workplace, they are temporarily laid off so that you continue to have the TER benefit for your company, the temporary employee relief benefit for your company that many of you presumably are enjoying at this moment in time. The purpose of dividing your workforce into 3 over and above the very small skeleton staff, which in stage 1 would have been preparing the workplace and making it ready for the return of your employees. The purpose of bringing them back in 3s is for you to be able to document and evidence the reacculturation process over a number of days. Now, what that means is that they have to come back. They have to have been informed beforehand of what the protocol is back in the workplace, the entire protocol and what's expected of them. And then they have to be given the opportunity of working within a workplace with that protocol on a repeated number of days for you to, number 1, iron out the niggles of those policies and procedures, and then number 2, for you to be convinced that you can now invite the second group or 33% of your employees back to the workforce, back to the workplace, and so reacculturate them under the auspices of the first group that has already been acculturated, and then the third group similarly. The spacing between those 3 groupings is conventionally understood to be at least a minimum of 5 working days or a week. So your first 33 could, for argument's sake, return to work on the 11th, and then the next 33 on the 18th, and then the final 33 on the 25th or the 26th, so that you've equally spaced the returns, but you've documented the fact that the group that's coming back to the workplace have been properly pre-trained, properly acculturated, and are proven to be competent. What you have to understand just finally in this regard of the 4-stage process is that you have to appoint someone who is going to be both the compliance and the communication officer on COVID in your workplace. It's a legal requirement that you appoint someone who is going to be both the compliance and the communications officer back there in the workplace. Okay, so that is your 4-stage reintroduction of your employees back to the working environment. The tough decisions you have to make there is, who do we choose in which categories to bring back in each of those 33% components? Now, this, I'm going to reiterate it. Who do we choose? So if we have a group of, for argument's sake, 15 pickers and packers, coming back to the workplace implies that they are essentially coming back to full-time work, and therefore that they will be paid for the work that they do, and therefore that they will no longer be required to sacrifice leave which is due to them, and alternatively that they won't be on an exclusive temporary employee relief subsidy program from the UIF, but that they will be fully fledged and entitled to a full salary. Having said that, if you've got 15 pickers and packers, essentially we're saying that in each category of employment, we would be looking at 5, 5, and 5 out of those 15. 5 to return on the 11th, 5 to return on the 18th, and 5 to return on the 25th. How do you choose which 5 will be in which category? That becomes a little bit of a labor relations challenge, because what you've got to realize is that the moment you make that choice, you make that choice on the basis of preferring one to another, and therefore of agreeing that the one who is returning soonest will be in a much quicker position to get a full salary than the ones who remain on lockdown and therefore in a state of temporarily being laid off. So that is your first tough decision about that 4-stage reintroduction. What are your criteria for choosing who it is who will come back quickest to the workplace? Ordinarily, you could apply a labor relations stalwart tool, which is the notion of last in, first out, which basically means first in are the people or the oldest people in the job, the more experienced people, potentially the longest serving people in the job are the people you might invite back to the workplace first. And the youngest people in the job, the novices in the job, the assistants, the people still in the incubation or in the probationary period would be the people in that final category 3 of 33, 33, 33 that you're inviting back to the workplace. But you have to, not only in your minds, but on a documented basis, you must be able to document that tough decision. Who is it in each job category that I'm going to prefer in returning group 1 as opposed to 2 and 3? And how am I justifying that from happening? The question was asked of me this morning, could we not turn it on its head and talk about qualifications? Yes, you can. You can talk about the fact that we want the most qualified people, the most competent and qualified people in each of those 3 returning categories coming back soonest, and the least qualified, the people who are in the job the least, the people who've got the less amount of competency, possibly only because they haven't been back in that job for a long enough period, will come back last. There is absolutely nothing forcing you to have one criteria over another, but you have to have criteria. You have to have a documented process of being able to explain to yourself why you're preferring some staff members to other staff members. Bill has asked a question. He says, surely the 33% can only apply on businesses of scale. Bill, ordinarily, I'd say absolutely. And if you've got 2 or 3 or 4 people, then there's no question that you can have all of those people back at the beginning. However, it's incumbent on you to discharge your responsibility to show that you prepared the workplace properly, that you had standard operating procedures in place, that you have got your posters and your documents, and that individuals have been, there's been a risk assessment of the workplace, and the individuals have in fact been copied before they come back to the workplace with the rules under returning to work, So my answer to you is, Bill, if you're employing 3 or 4 or 5 or up to 10 people, I would say, then you're pretty safe letting them return to work in one group. However, one cannot account for overzealous inspectors who march into your workplace and say you're breaking the rules. We will only know, to be honest, if you are breaking the rules, when they tell you you're breaking the rules, and if it is a dispute of interest and not a dispute of rights, then you're fully entitled to challenge any punishment or challenge any fine, which in fact might have been foisted upon you. And what I mean by the difference between a dispute of interest and a dispute of rights, I think is critically important, Bill, to point out to you at this stage. What is meant in that regard is this, that a dispute of interest is something for which and around which there is no law, there is no standard operating policy, and in fact, you're expected to make it up as you go along. That's a dispute of interest. A dispute of rights is if there was a regulation and you're breaking the regulation, then that individual who is the victim of you breaking the regulation has a very clear dispute of right against you in terms of the right that's being conferred by the settled law to be able to challenge you and to do all sorts of nefarious and horrible things to you. There's no question that as far as the size of the business is concerned, that would very much be classified as a dispute of interest because it hasn't been clarified in regulation. It's not being clarified in law. And if anybody wants to impose a fine on you, 10,000 Rand fine, in some instances, if you take the Minister of Labour last night by his word, he will close your business down without a second thought. And I'm quoting him, I'm not putting words into his mouth. Then, in fact, you're entitled to challenge that straight away on the basis that it's a derogation of duty, that it's a dispute of interest, that it is a public administration and a justice action you would have against that particular official or that government department for exceeding the bounds of their authority. So, Bill, my answer to you is yes, if you're a small business employing less than 10 people, the assumption is that everyone can return to work at once, as long as the workplace has been readied properly beforehand. And we will only know if you are in fact breaking the imagined right, because it doesn't exist in law or regulation, if you're challenged and if you're fined and if you have to deal with the consequences of being on the wrong side of some Gestapo practitioner's idea of what the law says or doesn't say. And I'm sorry to be so blasé about how I've responded to your question. Okay. Now, the next point I want to get to, ladies and gentlemen, is the point of what 33% actually means in your business, because you have one of two models you can apply. It either relates to your company as a whole and all your employees as a whole, or, in other words, 33 of 60 people is 20 people a time returning to work. Or it could relate to the divisions. We have 5 divisions in the business. They are relatively standalone divisions. And the most critical division is not receiving or logistics or dispatch, but is in fact manufacturing. And therefore, let's get the manufacturing division right with as many people in it as possible. And then in the second week and the third week, we can bring on the supplementary units of the business. And each time we bring them on, we can bring on entire departments. How you divide up that 33% against the critical mass size business is totally up to you. Divisional allocations are as legitimate as simply 3 divisions of your entire staff complement or your total staff complement in your business. So you need to be aware of that. Tough decision is this. A tough decision is, out of a total staff complement, how do I divide up 33, 33, 33? It's less tough if you're going to do it on a divisional basis, but your tough challenge then is, how do you explain to the divisions who remain on lockdown and whose staff remain temporarily laid off, how do you explain to them that they're not victims, but it's just part of the planning of the company? You have to document your thought processes, your decision-making processes. I'm astounded, and I need to say this, I'm astounded by what I'm discovering is that the trade unions are consciously at this stage taking a back seat and not engaging with the companies on some of these decisions. What they're presumably doing is waiting for the companies to make a mistake and create a dispute of rights, or what they perceive to be a dispute of rights, that they can then either challenge in the bargaining council or at the CCMA, or if it results in some kind of a retrenchment, group retrenchment, then certainly in the labor court. Rob says, I take from what you are saying that each new third gets added to those already back. So after 3 weeks, you will have all of your staff back. What happens if you do not have work for all and only want 50% back? Very good question, Rob. So the answer is this: you do not have to take everybody back. You can be partially locked down. Your staff can be partially laid off. There is absolutely... Sorry, I don't know who you... I'm just going to put everybody on mute for a second. Okay, I've put everybody on mute. Apologies for that. I'm not sure whose that was. So, Rod, in answer to your question, then, you can be partially locked down. Your staff can be partially laid off in terms of who and numbers. That is absolutely up to you. And importantly, you can decide, for argument's sake, that jump between the first 33 and the second 33 and the third 33 is a month apart. You can decide that we are only going to bring people back gradually a month between those groups. That's absolutely up to you. The issue and the challenge and the tough decision is not your decision itself, but your justification of that decision. And all you have to do is be able to document in writing so that any inspector can see what you've documented. They cannot challenge you on the merits. They can only challenge you on the process. And the process is simple. Document, communicate. You're not required to negotiate. So document and communicate. You're not required to negotiate. Is there someone who wants to ask a question? I can hear that a microphone's been unmuted. Okay, let's carry on. Please feel free to ask questions like people already are in the chat facility, or if you want to unmute your microphone and audibly or vocally ask the question. Okay, so thank you for that, Rod. So it's absolutely up to you to stay at 50% capacity. Now, I do want to say this, that if you look at the 29th of April Government Gazette, which lays out the companies under alert level 4, or rather the industries under alert level 4, which will be allowed to come back to work, if you look there, there are a number of catchment inclusions. For example, trading as e-businesses rather than physically in a shop or in a facility. Number one, that's a catchment area. Number two, under manufacturing, all other manufacturers not listed in the list will be able to return back to operation at 30% at this stage under level 4, at 30% of your capacity. So, Rob, there's an answer to your question. If you fall into the other manufacturing category, the maximum you're entitled to extend yourself up to there is 30% anyway, not 50%. So you have a lot of flexibility and freedom. If you are one of the industries that are indicated as being able to return back to work completely, it doesn't necessarily mean you have to open at full complement. The decision and the choice is absolutely yours. The tough decision, however, when it comes to your staff, is your being able to distinguish who you want back and who you don't want back. That needs to be documented. And from a procedural point of view, it cannot smack of victimization or marginalization. And again, unfortunately, that's an art, not a science. But on a one-to-one basis, we'll get into that because there are obviously ways of doing it properly and ways of not doing it correctly. Bill says, given that this is about health and safety in the workplace, do these quotas include or exclude staff working from home? Well, the reality is the staff working from home would be excluded for purpose of your standard operating protocols and procedures. So the reality is you can keep staff work. In fact, you are told anyone over the age of 60 or anyone with one of the indicated diseases such as diabetes, lung problems, respiratory problems, etc., you have no choice but to leave them at home. Critically important from a staff and a labor relations perspective, you have to leave those people at home, Bill. And it's only the people who are capable and able to return to work. And again, your standard operating procedure will say, as long as they don't have COVID, as long as they're not positive when it comes to COVID, because then they go straight home, straight into quarantine and whatever else is required. In the larger workplaces, please always bear in mind that you are required to create quarantine facilities so that the moment someone is detected as potentially having a temperature over the minimum level, you put them straight into that section until a doctor has seen them or some other kind of mechanism in your standard operating protocol so that you've cleared where they need to go to from there. So just be aware of that all of the time. So let me move on now to the notion of what reduced hours means. And Rob, to some extent, this might talk to your question as well. So there is no question in anybody's mind, particularly, for example, in retail, that when you open your doors today, the 4th of May, you're not going to hit the ground running. Your customers are not back at work or are not 100% full flowing either, and you're simply not going to hit the ground running. Now, you are fully entitled to say to your staff that even though the 33% of you who are coming back to work today on the 4th of May, for the next month, we are only going to be able to utilize you anywhere from 30% to 60% of your normal working hours. And therefore, we're informing you in writing that your choice is you work to that 50% of your normal working hours. You accept that we're cutting your salary by that 50%, with the alternative that you accept temporarily being laid off and you reverting to the TER formula, the temporary employee relief formula, that says that the maximum you're going to get is the TER scale and nothing else. We might allow you leave encashment if you've got any leave left, but beyond that, nothing else. So your choice is simple. You accept the 50% of your working hours at 50% of the pay, or you choose to be temporarily laid off and rather resort to a TER application. And within 5 working days of us getting the money from TER, we'll pay the money over to you as the temporarily laid off employee for that period of time. So as far as reduced hours are concerned, it's not the subject of negotiation. It's simply a subject of stipulation. We call this the recovery period. You can determine how long that recovery period will be. You can say it's going to be a month, 2 months, 3 months, depending on how our customers and our clients themselves are recovering. And it's a standard accepted principle that there will have to be a recovery period that you're making allowance for after returning to work. It's highly unlikely that you'll return to work at 100% of your capacity. In fact, the reality is that the 33% story indicates that there is an assumption that there is a 3-period recovery process that you can extend to 3 months if you wanted to. So critically important from a reduced hours point of view. Now, what I do want to say about reduced hours is even though that's a tough decision, do I decide to put my staff on reduced hours? The UIF will allow an employee to come to it individually and say, my hours have been reduced. Here is the proof of my hours having been reduced. And I want to be covered by this insurance policy called the UIF for reduced hours, reduced time, reduced income. And there is UIF cover for that. On the same sliding scale, that applies to TER. In other words, 60% of your salary at the lower level, up to 38% of your salary at the higher ceiling level. So that's how reduced hours. The only difference between TER and reduced hours is that the company applies for TER, whereas the individual affected employee applies in their own right to the UIF for compensation because of reduced hours. What you're also entitled to do, ladies and gentlemen, is the notion of job sharing, which will obviously result in reduced hours or alternatively alternating shifts, which are for UIF purposes classified as reduced hours anyway. So job sharing might result in alternating shifts, or in fact, it can, if everybody is back at work, it can also result in a retrenchment, subject to what I'm going to talk about a little later of how you, in fact, manage that retrenchment process. Work from home is an option you give everybody. You have to give everybody the option of remaining laid off on the one hand, or alternatively, working from home if they are non-blue collar employees, I would imagine, because it's very difficult to get a blue collar employee who works on a machine or a production line, or drives a truck or something like that to, in fact, work from home. So you need in your work from home process, in your risk assessment and in your communication strategy to your staff, to be able to say who qualifies to work from home, why they qualify to work from home, and whether or not they too would be on reduced working hours or not. So you need to be able to communicate that on a person by person basis, and your broad stroke policy on a group basis in terms of working from home. Before I carry on, I see that Natalie has asked 2 questions. Will the employee applying for UIF directly still be delinked from the UIF rules of 4 years work history to qualify? Natalie, I don't know. My gut feeling is this. My gut feeling is that everything outside of UIF TER is business as usual, which means that if they are linked, if they are delinked, if they are individuals who have to apply in their own right, quite frankly, then they will not be dealing from the UIF. The same rules of 4 years work history will apply in that particular instance. No exceptions have been gazetted to the best of my knowledge. There have been a couple of gazettes this afternoon from the Department of Labor. I will be looking at them and I'll be circulating them a little later. But as far as I know, and as far as I am aware, there is no delinking from the traditional and normal rules of how all of the rest of UIF works, with the exception of the temporary employee relief. That particular aspect of reduced hours does not relate to the temporary employee relief provision, which has recently, as of 6 weeks or 8 weeks ago, been implemented by the Department of Employment and Labor. Natalie also asked, will the employee applying for UIF directly? And it's the same question, sorry. Okay, good. Let's move on then. So work from home, critically important again, ladies and gentlemen, that you do distinguish who is eligible and entitled to work from home, and what any conditions will be in terms of reduced hours as far as those people are concerned. I'll give you a practical example of what I'm saying. One of my clients has a whole lot of sales staff who ordinarily would be expected to go out there, meet face-to-face with the client base, cannot do that, have worked for the last 6 weeks from home, but on reduced hours. So they've worked from home, but because working from home allows them to cold call, possibly do orders over the internet, etc., that amounts to about 40% of the normal requirement. So their salary has been reduced by 50%. For that period of working from home. That 50% still amounts to more than what the UIFT or compensation would have amounted to. And that's why both the individual and the company made the call that we're prepared to take the 50% reduction in our hours and in our salary, because it's more than we would have got out of the UIFT or temporary employee relief. Michelle asks, how long can you keep staff on reduced hours and job sharing? Well, Michelle, certainly for the full period of 5 until 1, 1 indicating that lockdown has been suspended and lifted. So as long as lockdown lasts, for certainly, you can keep staff on reduced hours and job sharing if you need to. However, if it is patently obvious that a demand on your product or your service is picked up to the extent that it's basically normalized, it's going to be very, very difficult from a labor relations perspective for you to be able to justify why your staff are still on reduced hours and even job sharing. In other words, that your temporary precautions cannot be reversed if it's business as usual in your particular business. So you just need to bear that in mind. As far as your over 60s and your vulnerable employees are concerned, you are breaking the law if you allow them back into the workplace. You are breaking the law if you invite them back into the workplace. You are breaking the law if you encourage them to come back into the workplace. You are not allowed to have a person over the age of 60 working in your workplace. And this is a health reason, simply because they are the most vulnerable. They can work from home, very definitely. They can work remotely, very, very definitely, but they cannot work in your workplace. Now, the difficulty as far as your vulnerable employees are concerned is both a tough decision, but it's also an opportunity. And what I mean by that is this. We very seldom get the legal right, legal permission, legal license to ask our employees to declare that they are in some way or another disabled, or that they are in any way infirm when it comes to vulnerable group categories. So the very first thing you should be doing in your risk assessment in your business for all employees, whether they're in their 33 groups, or whether you have their email addresses and you can communicate with them on an ongoing basis, the very first thing you should be doing with them, ladies and gentlemen, is getting them to declare that they have a vulnerability in terms of physical, such as, for example, diabetes, cancer, respiratory disease, or anything which would make them susceptible to the coronavirus in any way, in any shape or any form. And importantly, to get them to declare any what we call hidden disabilities. So a hidden disability would be any of the things I've just mentioned to you and a lot more. The kind of things that would make them medically classifiably disabled, but which you cannot see, you have not known before, it's not been disclosed to you before, but needs to be taken into account. You need to make it very, very clear to all of your staff in writing that if they fail to disclose to you a vulnerability of any nature, which is known to be a vulnerability to coronavirus, and you discover that they had a predisposition, they had a medical condition or a predisposition at some stage in the future, even after lockdown has been lifted, that is a dismissible offense, and you need to make it very clear to them in writing that it's a dismissible offense. So they either declare to you, in which case you agree they can either work from home or they remain on temporarily laid off status, which means they qualify for UIFTER. But if they do not disclose that to you, if they come back to work, if they expose themselves, but in the process they become a carrier for whatever reason of the virus, that is immediately a dismissible offense should that evidence ever come to light. You are never, ladies and gentlemen, as employers going to have this opportunity again to push full disclosure of this nature through in your staff relationships. Full disclosure of this nature through in your staff relationships. you need to make it very clear, ladies and gentlemen, that if you are vulnerable in any way, then we will allow you in some form or another, if you are able to work from home, if your job requires it, or if your job permits it. Or alternatively, we will put you on UIF, we will make you temporarily laid off so that you qualify for UIF, temporary employee relief. And we might, in that instance of your declaring a medical complication or a medical predisposition, we might in that instance decide to make a company grant to you to encourage you to stay temporarily laid off until the danger of COVID has disappeared and we've achieved level 1 status. It's an art, not a science. How you make it happen, how you engineer it is absolutely up to you. But part of your risk assessment and your risk strategy that you communicate to your employees has to be around the issue of the vulnerability of your employees. I've spoken a lot about to deter or not to deter and the various advantages and disadvantages. What's interesting is that today there is a regulation that's just come out in the last 10 minutes, being gazetted, and that regulation says this. It says, in the instance where you are locked down, you have no choice as a company but to apply for temporary employee relief. So the Minister of Labour has now, as of today, made it absolutely a requirement that if you are locked down, if your business is closed, then you have to, on behalf of every single employee who is temporarily laid off, you've got no choice but to apply for temporary employee relief. So I cannot overemphasize that today has become even more of a requirement. So you don't have a choice as to your employees who are on temporary layoff. You have no choice but to apply for a UIF, temporary employee relief, as far as they're concerned. No work, no pay. We'll apply for temporary employee relief. When we get the money, we'll pay it over to you in 5 days. Although an additional thing that has been gazetted today in the last couple of minutes is equally that you are entitled to make a prepayment to the individual against which you can offset temporary employee relief. That's been a gray area up until now. It's now been set in concrete as a regulation. I will be passing all of this on to you via our various WhatsApp groups, and also I will be passing it on to you via our email newsletter. I do encourage you to send me your email address on 082-880-5316, my WhatsApp number, 082-880-5316. I'll repeat that at the end of this discussion. But I do encourage you to send me your email address so we can add you to the newsletter, so that as these gazettes come out, we can put the gazette and the interpretation of the gazette and any supplementary tools we develop along the way, we can put that into that newsletter directly to you, because you need to know the law's changing almost every hour, if not every day. So good. The final component of the tough decisions I want to talk about is this issue of leave encashment. Now, leave encashment means this. Leave encashment means you're entitled to say one of two things to an individual. It's no work, no pay, but we will allow you to encash your leave. And when we get TER back, we can set it off against the encashed leave and therefore give you your encashed leave back. That's just being gazetted as a third component now. So whereas previously you would use encashed leave to make up the difference between the TER and as much of the normal salary that the person needed, you are now able to say, we will allow you to encash your leave with us so we can advance you the value of the leave. We will apply for UIF TER. When we get UIF TER back, we'll give it back to the employee in terms of the leave that they encashed. It still doesn't talk to that gap, however, that gap between the person's actual salary and the value of the UIF TER. You are fully entitled to give the employee the option of making up the difference between TER and their full salary by using leave. It's just been made easier for you to manage as of a couple of minutes ago. All right. Any questions about what I've said before I go on to my next slide, ladies and gentlemen? Because I know I've said a lot, and I know I'm saying it quite quickly. I really do not mean to be rushing.
Sorry, Ava, it's Dalmaray. Yeah, I just want to find out something with regards to the leave encashment. Now, a lot of us will also be cash flow strapped. are we forced to for them to do the encashment of their leave? I know that it's money that's due to them, that I do understand.
So let me ask your question a different way. The question could be, are we entitled to say to staff, it's no work, no pay, except for UIF TER when we get it back from the UIF? Is that your question?
Well, kind of. I mean, a lot of my staff members do have substantial amounts of leave, but I mean, if they, we're not in a position at this stage from a cash flow perspective to be able to still pay that out as well. I mean, we've been in lockdown, so there's no income.
So, Delmarie, I'm going to say it again. You are entitled to say to your staff members, unfortunately, we have no cash flow available to be able to make advances to you of any nature. So we can't advance you your UIF TER. We certainly cannot advance you any leave which is due to you at this stage. And therefore, also because we don't want to force you to have to take your leave at this stage, we are saying to you that it's a no work, no pay situation if you're temporarily laid off. However, the moment we get the UIF TER back on your behalf, we will immediately, within 5 days, make that payment to you. You're fully entitled to do that.
Okay, excellent. Thank you very much, Ava.
Michelle says, has the criteria changed for UIF TER submissions? Have submitted twice and staff still not received. Michelle, I'm sure you've seen the petition, not the petition, but the questionnaire that's been circulating by us. I need you to fill it in, give your complications, etc. There are major, major problems. Do not believe, in fact, don't believe anything you heard from the Minister of Labour or any of his Politburo last night on television. As far as we're concerned, with a number of complaints coming in from businesses we deal with, it's absolute rubbish, absolute lies. The reality is virtually every workplace has been underpaid. The criteria were not clarified or upfront. There was no clear understanding of who was going to get paid what. There's certainly no ability at this stage to appeal because even though they say, you can send us an email, you can phone our hotline. If you look at the complaints that have come in as a result of that questionnaire we put out, and we're going to be sending out a report. The report, by the way, is going to the Parliamentary Portfolio Committee on Labour because, as far as we're concerned, the commission of the UIF, every one of those bureaucrats who were on television last night, and the minister should be marched out of their offices, never to get employment again. They have completely lied to the South African public, as far as we're concerned, based on what they said again last night. So my answer, Michelle, unfortunately to you is we have no idea whether any of these criteria have changed. We are chasing them up all the time. But the way things are at the moment, you cannot rely, number one, on getting TER back because it's a crapshoot if you do or you don't. It's a lucky packet draw, quite frankly. And then if you do, you cannot in any way anticipate how much money you're going to get back because those formulas keep changing. And the bureaucrats in those departments are absolutely inaccessible to be able to help you. I wish I wasn't sounding so damning, but what I am saying to you is get your employees to depend on the TER, but don't make your strategic planning decisions on the basis of TER. What I can tell you as well, and we heard this clearly last night from the minister and his bureaucrats, the minister is saying this: we are publishing a list of all of the companies that we've paid out, and we are publishing the amounts that we've actually paid out to them. Now, this was announced last night at the media conference, and it's what they're doing on their website, but they're literally saying to employees, go online, see if we've paid your company, look at how much money we've paid your company, and then ask your company why they haven't paid you back that TER money. Not saying to the employees that the money received has been received on behalf of the entire workforce. If you're a foreigner, no foreigner, even though UIF's been paid on their behalf, no foreign employee has had TER paid out on their behalf. The formula applied to how much is calculated for you to receive back has been changed again and again and again, and therefore we've paid maybe 5 cents on the rand, but said we've paid back on your behalf. So that, unfortunately, it's an oppositional war that's been created against employers by the Minister of Employment and Labour, and it's been done purposefully to drive a wedge between the company and the employee. So that, unfortunately, is the current state of affairs. We'll most probably have to run a separate webinar on that because we certainly don't have time to do that here. I'm sorry, Michelle, I would have liked to have given you more definite news. All right, moving on. All right. So, ladies and gentlemen, I'm very quickly going to glance over performance management issues because I don't need to tell you how to performance manage your staff except to deal with some specifics. And that is, number one, that the very first stage of performance starts again today on the 4th of May. Because as your employee returns to the workplace, so it's incumbent on you to assure yourself of the following. The person has a job description. There is a performance contract in place against that job description. I regularly am appraising their performance, and I'm regularly giving them feedback in a performance management loop. Equally, if I need to move to stage 2, which is the counseling stage of trying to correct competency, I'd never counsel on behavior. I go straight to discipline on behavior. But if I'm counseling on competency, I must be very careful not to depend on pre-COVID counseling, but I'm going to need to reinitiate at least the results of the counseling activity, which might have been an email or a letter to the individual, if not the process of the counseling activity, because I must accept that during the temporary layoff period, it basically suspended the effect of the counseling that I had had with that individual, and I need to reinitiate counseling to make sure that as they're back at work now, they know what I don't like about their competency performance, they know what needs to be addressed, and whatever period of time I gave them before COVID to address the issues which are being counseled on, I need to extend that period of time for the period of the 6 weeks of COVID, because COVID suspended the period of performance on that counseling phase of performance management. I know I'm not telling you anything new, but I'm just emphasizing the point. COVID, the 6 weeks of being on lockdown, suspended any performance or counseling activity, performance-related discussions or counseling-related activity, which might have taken place in the period before COVID. Any questions about that? Because it's quite a tricky thing to wrap your minds around if you're not been practicing it on a regular basis. Okay, let me continue. As far as discipline is concerned, just as COVID suspended any counseling performance activity, so COVID suspended any disciplinary activity that had not been completed prior to the 27th of March. So, practical example might have been a disciplinary inquiry, which was suspended because the chairperson wanted to think about something, not necessarily his ruling or her ruling, but to think about something or to investigate something. Or one of the sides said, can we please have a postponement because we need to get more evidence or get another witness or whatever it is. COVID completely suspended that period. And so if the chairperson said, I agree to suspend this inquiry by 2 weeks, those 2 weeks only start on the 4th of May. Those 2 weeks didn't start on the 27th of March. I do need to emphasize that, ladies and gentlemen. You do not want to be on the wrong side of a dispute of right here. And the dispute of right is that during COVID and a temporary layoff, all ongoing all ongoing activities are frozen until after the lockdown is lifted or until after, for example, some of us can go back to work on the 4th of May. So you please have to understand that. Discipline will reconvene today as if it was the 27th of March. And everything between the 27th of March and the 4th of May is a no-go zone. Temporarily lay off means our business has been shut for that period of time. Natalie asks, I have an employee on probation that is not up to scratch. There were 2 weeks left before lockdown. Can I end the contract as per our signed contract that says 1 week notice from either party during probation period, or must I give additional time? Natalie, 2 things. The 2 weeks left means that it got frozen on the 27th of March, and you can only pick up on it on the 4th of May if you are a company that is allowed to go back to work. So if you're not still in lockdown, then the 2 weeks will start from today, not from the 27th of March. That's the first thing. And the second thing is, if it said 1 week's notice from either party during the probationary period, because the probationary period, that 2 weeks, didn't expire during April, but will only expire 2 weeks from today, the 4th of May, during that time, you can give that 1 week's notice in terms of your own policies and procedures quite simply. But I just need to caution you that there is more than enough evidence and more than enough precedent at the Labour Court, the CCMA and bargaining councils as well, that says a notice of probation has to come with reasons. You have to be very specific that notice of probation has to come with reasons, normally pursuant to some kind of a meeting, some kind of a chaired meeting, some kind of an opportunity for what in law we refer to as audit ultram partem, hear both sides of the story. So please, Natalie, I'm now talking to you as a labor advisor. I'm not talking to you as a COVID advisor. I'm saying the normal labor relations, basic conditions of employment act, bargaining council agreements, statutory provisions from the Department of Labor, all of that still applies, particularly now after the 4th of May if you're a company going back. But even if you're a company in lockdown, lockdown means our doors are closed, our doors are frozen. It's not business as usual. Business as usual either only happens after we've got to 3, 2, or 1, and we can go back to work, or it happens after the 4th of May if we're lucky enough to be a level 4 company that can go back to work. Critically important, Natalie. Okay, the one thing I do want to say, ladies and gentlemen, is please make sure in your minds that you understand the difference between competence and behavior. Now, behavior allows you to take quicker action, more speedy action that doesn't require counseling. So a behavioral infringement means that if I'm coming back to work today on the 4th of May, and during the morning of the 4th of May, if there is for example, there's a drawing on the floor that says one person stands here and another person stands there, and yet I nonchalantly walk in the middle and I stand right on top of someone and I speak to the person directly. So I'm disobeying the behavioral rules in the workplace, got nothing to do with competency. I can immediately be subjected to disciplinary inquiry. And because it is so severe, I can literally kill the person I was standing next to. I can be dismissed on the spot summarily for that offense. As long as prior to that, I was informed about what the rules were. Coming into the workplace, I was inducted as to what the rules were again. If I'm now operating in the workplace and I act like an idiot, I can be summarily dismissed on the spot. There's no such thing. Well, there never is. I don't know where majority of people I speak to have this notion that there's a step ladder approach to discipline, that you have to have a first warning and then a second warning and a third warning and a 10th warning, and on the 20th warning you can dismiss. There's no such thing in law in this country. There are some bargaining councils that have entrenched that requirement in their bargaining council agreements, but generally there's no such thing in law. If there's a behavioral problem, I've established the facts of the behavioral problem, that person can be dismissed there and then. And then they can be dismissed summarily, which means with no notice pay, or with notice pay. So the point I'm trying to make to you, ladies and gentlemen, is there has to be consequence management in the workplace from today. And the extension of consequence management is how they are following social distancing requirements, health and hygiene requirements, etc., etc., etc. Not just what applied to them before the 27th of March, before lockdown was initiated. Cannot overemphasize that fact. All right. Oh, is there a question there? Yes, sir.
Yes.
Sorry.
Hi, Ivor.
Yes.
Ivor. Delia here. I just want to find out during lockdown. Hello, Ivor. During lockdown, is leave accumulated?
No.
Because we're only going to open on level 1.
No. So thank you so much for that question. That's a beautiful question. Delia, the answer is this. During lockdown, it is a no work, no pay situation, and leave is not accumulated. There's no other way of putting that answer to you. During lockdown, it's a no work, no pay situation. Leave is not accumulated. You accumulate 1 day's leave for a certain amount of application on the job. You do not accumulate leave for being temporarily laid off.
Thank you, Ivor.
No problem. Any other questions before I carry on? Good. Let's move on. So now we get to the sexy thing, this thing called 189. Please, ladies and gentlemen, I know we've gone massively over the time. If you do need to leave, feel free to leave. This session is being recorded and will be distributed. But you'll be missing the really sexy part of this discussion. I do need to warn you. All right. So now we talk about the fact that entrenched in our law is this, that while you are not required to negotiate with your employees, you are required to consult with your employees. The difference between consultation and negotiation on any 189 matter is that consultation needs to be where you give the employees an opportunity to engage with you in I suppose, the same term, audit ultram partem. Hear both sides of the story. My thinking is I want to close down your division. My thinking is that we'll only need half of you, that we can then move on to other departments in the organization. So 50% of you will need to be retrenched from the business. And my thinking is that for those of you who are moving over to another division, because we're closing your division down, you're going to need to go through 6 months of training of some sort or another. And if you don't pass through the training positively, at that stage, we will then retrench you. What do you think? No, sorry, we don't agree with that. We think that our division is absolutely critical to the business. We think that this is just another way of you trying to avoid having to pay us a retrenchment package or having to keep us on salary. Thank you very much. I've heard what you had to say, but I'm still going to do it. Now, that's consultation. There is no need for negotiation in a Section 189 process, because invariably they're going to go to the CCMA or bargaining council anyway, and the labor court if it's a collective group of people, and try and squeeze something out of you anyway. So the reality is there's no need for negotiation, there's only need for consultation. Negotiation is, we say you shouldn't close the division down, these are our reasons, and you have to follow what we're saying. In other words, we have a position of power and authority in the business. We are entitled to have ourselves listened to, and we are entitled to oblige you to have to act on what we're going to say. That is not the way Section 189 goes, ladies and gentlemen. You have an obligation to consult. You don't have an obligation to negotiate. So, Section 189 is what comes before the process, essentially of retrenching or reorganizing divisions, putting people into different divisions, putting people on short time, reduced hours, job sharing, and all of those other good things. Always by agreement, by the way. The consequence has to be agreed to, and an alternative to the consequence has to always be provided to the individual. So you either take a retrenchment package or you move into another division and we reduce your salary by 50%, whatever the result could be. So the point is this. If you had initiated a Section 189 process before the 27th of March, before COVID started, then you are fully entitled from the 4th of May, if you're returning to work, you're fully entitled to continue with the Section 189 process. But what you're not allowed to do is apply the consequence of Section 189 decision that might have been announced on the 26th of March, anytime in April. So you're not allowed to retrench. You're not allowed to go on short time or half time because of the Section 189 process during lockdown. You're only entitled to do that after the 4th of May if you're one of those companies in alert level 4 who is allowed to go back to work. So lockdown completely freezes the continuation of a Section 189 process or the implementation of a Section 189 decision. I cannot emphasize that enough. You are on your own if you've made a decision to retrench or go on short time while your employees are temporarily laid off. You have violated that concrete wall between you and your employee who is not your employee during the period of them being temporarily laid off. You've literally punched a hole in a concrete wall, which is impossible unless you're Thor. Any questions about that? Because that is critically important. I'm already seeing a number of my clients who are erring, and we're needing to pull back. We're needing to re-examine the decisions. Any questions about that?
Please just repeat that again, Ivan.
Hello, Greg. How are you?
I'm fine, thank you.
Very good. Okay. So, Greg, I'm saying this to you. If during the month of March, you initiated the Section 189 process, which says, dear employees, we are going to have to examine every aspect of this business because either for economic reasons or operational reasons, we're going to need to make changes. Economically, it's a very bad time. We know we're headed for a Moody's downgrade soon. I'm talking as in March. We know we're headed for a Moody's downgrade soon, and we're simply not doing the turnover or at least the profitability that we used to, and we're going to have to trim. We're going to have to trim in terms of what we buy into the company. We're going to have to trim in terms of the people working in the company, et cetera, et cetera. So you initiated that process before the 27th of March, 26th of March. Okay, good. Come the 27th of March, you might have completed the process because remember, you only need 3 working weeks. Some people say 2 working weeks, but err on the side of the caution and say 3 working weeks from when you've initiated Section 189 to when you are allowed to make a final decision as to what you're going to do. So within those 3 working weeks, let's say that 3 working weeks ended on the 25th of March. And on the 26th of March, the CEO of the business wrote a letter to the employees to say, as you know, we've been through Section 189. We've examined all the options. Here is everything we've examined. And we've decided to retrench 60% of you. That's fine. But that retrenchment gets frozen the next day. It gets frozen on the 27th before it can be enacted. And because it gets frozen on the 27th, it can only be reassembled and implemented on the 4th of May if under alert level 4 you're allowed to come back to work. You can't implement during the month of lockdown because temporary layoff means there is a concrete wall and you cannot get through that wall to your employee who's not your employee for the period of the lockdown. Does that make sense, Greg?
Yep, that's perfect. Thank you.
Okay. Any other questions on that, ladies and gentlemen? Because it is critical. Okay.
Ira?
Yes, Renee.
Hello. How are you?
Oh, fine, thanks to you. So good to hear your voice again, Renee.
Okay. I want to know, you're saying it's illegal to do a Section 189 during this time?
Absolutely. During lockdown,
So
not if you're back at work now.
I know of 2 companies that have done that, and they're huge companies. One's international.
Well, then they're nincompoops. That's all I can say to you.
So what recourse have the staff got?
What recourse have the staff got? It's an unfair labor practice. They can immediately go to the CCMA if they can find someone at the CCMA, or if they're in a bargaining council, they can go to the bargaining council, or if it's been done collectively to all of the staff, they can go directly to the labor court.
Okay. Okay, one of them being my sister. Thank you.
Okay, so hold on a moment. So let me reiterate what I'm saying here. If you're telling me that after the 27th of March, a company sent out Section 189 notices to their employees, and then at the end of a 2-week, at least, if not a 3-week period during April, informed the employees that as a result of the Section 189 process that we initiated on the 1st of April, we are now retrenching 60% of you, absolutely illegal.
Okay.
Good.
Okay. I'll show you the details privately.
Fantastic.
Thank you.
Fantastic. Thank you. All right. Natalie says, I have an employee on probation that is, we've dealt with that. Okay. Natalie then says, I'm a level 4 company. Can I leave this manager that has 2 weeks of probation left before lockdown? May I keep him on TRS? Company requires a limited competent staff, can keep it on TRS till lockdown is removed from all companies. Claim TRS for him. He receives no leave accumulation. And then when all companies come back, I can bring him back for 2 weeks and nail him. Of course you can, Natalie. That's the whole purpose of this discussion. Absolutely. You've got it to a T. Absolutely. T. Ernest says, does that only apply to employees who have been laid off? Can you still retrench employees that have been working at home through lockdown? Interesting, good question, Mr. Ernest or Mrs. Ernest, whoever you are. T. I'm going to call you T. So interesting question, T, because the bottom line is, if that employee has been working at home, commissioned by you to continue working at home, doing administration or something on behalf of the company, then then the company is, for that employee's purposes, the company is not in lockdown. There is no concrete wall between you and that individual, and you have unfettered access to anything to do with discipline, performance management, counseling, or Section 189ing that individual. However, remember, Section 189 is a company-wide activity. You don't Section 189 one person, because the presumption of Section 189 is during that 2 to 3 week period of engagement and consultation, you're doing it as a group rather than with one individual. It's victimization if you 189 one person. I hope I've been clear and open and earnest. T. Ernest. Good. All right. Fantastic. Ladies and gentlemen, look, we've answered quite a few questions. I know there are many, many more unanswered. Please feel free to join by sending me your email address. Please feel free to send me your email address if you are not, for whatever reason, if you don't find yourself on our email newsletter. My WhatsApp number is 082-880-5316, 082-880-5316. Just send me your email address for the newsletter. Just say newsletter and give me your email address, and I will immediately then add you to the newsletter. We can get to many more people on the newsletter than we can in a WhatsApp group. Only too happy to then deal with your issue. And if it's an interesting enough issue, then we'll deal with it on our WhatsApp groups as much as we will also in the email newsletter. If it's about your rash, I promise to keep it confidential. However, while we've got another minute or two, are there any general questions anybody wants to have answered? No general questions. Okay, fantastic. That then either means we've dealt with a lot, or alternatively, it means you're too shy or you haven't found value. But whatever the case is, thank you all for attending. And this recording will be made available. Please send me your email address if we haven't got it already, so that we're actually able to keep you up to date with what's going on and all of these very interesting government gazette and changes. Did I hear someone who wanted to ask a question? Oh, hold on. There are two questions. Alexander says, what if a company that could have survived now struggles with the extended lockdown and will need to shut down waiting for the lifting? Well, then, Alex, the bottom line is if you have to shut down, then, in fact, you are either in a position to retrench your staff or just to lay off your staff if you cannot afford to retrench them. Remembering that your staff are always preferential creditors, which means that if you are going to, as a company, then go either into debt review as an individual, into debt review or sequestration, or as a company go into business rescue or liquidation, then your staff will always be considered to be preferential creditors against the legal persona of your company, not necessarily against yourself as a director of that business. So that's if you have to close the business down waiting for lockdown to end, unfortunately. Yes, you can do it via Section 189 if you have the time and the space and the resources, or you can simply take the action and bear the consequences. But the consequences will be very, very limited unless your neck is on the line personally as surety for your staff salaries and your staff compensation. What a nasty question to end a session like this off on, but thank you. Alex, look, the bottom line is chat to me, my friend, because really there are always options. So if you're in that state, just please talk to me first. Kate, a Section 182 notice may be published as a result of the lockdown, correct? A Section 182 notice may be published when you come back to work because of the damage the lockdown has caused, absolutely. So, and I suppose that's a little bit like Alex's question. If on the 27th of March we were okay, we were hoping for an uptick in business, and we had every reason to think we'd survive. Then comes the lockdown in April. Can the lockdown have driven us to a stage where when we open on the 4th of May, we've got no choice but to rationalize, and rationalization might mean a huge amount of retrenchment? Absolutely. You initiate it on the 4th of May. You take between 2 and 3 weeks to finalize it if you need to. And then by the end of May, you've actually retrenched people. Absolutely, in answer to your question, Kate. Ralph says, have you heard of anyone receiving the 2.6 billion promised by Minister for today? You're talking about the UIFTR? Yes, I've heard of a number of companies that have received part payment on temporary employee relief. Where they haven't received payment is, and now I'm going to make someone on the line who very uncomfortable or happy, depending on whether or not I fully understood what she's saying to me. So the reality, ladies and gentlemen, is this, that as far as temporary employee relief is concerned, remember that to give the Department of Labor its benefit, the UIF its benefit, it can only deal with companies which are formally registered on the CIPC, which is the Company and Intellectual Properties Corporation. So you're either registered as a business or you're not. If you're not registered as a business, even if you've been paying UIF, you are not going to be properly processed for TER. So TER is going to be turned away from you. You're going to be turned down. If your accountant has messed up in registering you, or in fact linking your UIF payments to a particular person, so that when you apply for TER for a particular person, there's no UIF payment against them, you're not going to be paid, but you can't blame that on the UIF. What you can blame is that the UIF will not allow you to remediate properly, will not answer your emails, will not answer their telephone calls, will not allow you to resubmit properly. That you can blame the UIF for. But you can't blame the UIF for the fact that you've not followed the procedural requirements to regularize your UIF payments or your company registration. So that's the first thing I want to say to you. Then, the UIF is paying out where the application, everything is in order. So the CIPC is in order, the memorandum of agreement has been signed, the CSV files have been properly uploaded. The UIF is paying out. There's no question about that. However, where there is a problem with a particular person's record, or the UIF imagines there's a problem with a particular person's record, it's not paying out. It's simply rejecting. It's declining, as they say. And if it's a foreign employee, even if they've got a work permit and even if you've paid UIF, they're not paying out in that instance either. So I have heard of the UIF paying out very definitely, Ralph. But then the third problem is that when they're paying out, Ralph, they're paying a fraction of what it is in their initial regulation they said they would pay out. And ex post facto, after the fact, they're talking about the formulas that they've in fact applied. So after the fact, they're now talking about the formulas that they've applied. To his credit, the Minister of Employment and Labor did say last night, however, to his credit, that there are a number of errors that have been made in calculations and miscalculations, and they are now going back and rectifying those problem areas where they know they've made a mistake. So my answer to you is, Ralph, yes, payments have been made out. Very few employers are happy with what they've been paid, where they have been paid, and most employers have not been paid anything. In answer to you, Ralph, I hope that answers your questions. Then, of course, there is a U19, which is now required for you to fill in for foreigners. So they're in the process of rectifying the foreigner requirement. If they've told you that that was the original reason for rejection or declining your application. So the U19 will be applicable to foreigners going forward. Good. All right. Anything else anybody else wants to know about, or are we going to end it there? All right.
Ida, can you hear me?
Yes, I can.
It's Delia here again. I just want to find out, as far as the TERS go, if you're going to still be in lockdown for another month or two, will you still be able to claim from them?
So absolutely. The TERS allocation, or rather the TERS system, was created initially for a 3-month period, April, May, and June. So you will be entitled to claim at the end of May. And if you're in lockdown at the end of June, you'll be able to claim for the month of June. If for whatever reason lockdown is extended, and we anticipate that in some regions, in some provinces, or at least in some cities, in some provinces, level 5 might be re-implemented. We've already heard the Premier of KZN say he wants KZN to be level 5. But if that does then happen, it is highly likely that lockdown will be extended beyond June. And the Minister of what the hell is he? Employment and Labour. The Minister of Employment and Labour has already indicated that if lockdown extends beyond June, that the UIFTR will be extended equally for the full period of lockdown, no matter how long it takes. So hopefully that answers you. Now, let me say this.
Thank you.
Hold on. You are not required to continue to reapply. Your application will simply mean that you have to submit your supporting documents to show that you've paid out the people that you've received UIF money for, and you will then automatically be paid out at the end of May and then at the end of June if it extends to that period and beyond.
Oh, really?
Yes, really.
Okay. All right.
Good.
Okay.
Thank you, everybody.
Thank you.
Thank you all for your time.
Thanks.
And thank you for sticking with us. I've really appreciated this engagement. And like I say,
Sorry,
please...
I've got one more question with regard.
Yes, Delmarie.
Abba, can you hear me?
I can hear you, yes.
I just want now with the last ladies saying about the COVID, can you reapply? But some of us, because we're one of the hardware stores and we were able to open, obviously there's only been 3 of us trading and we've just brought on a 4th person. If I resubmit my tours, I have to remove the 4 that have been able to work, right?
No. Yes.
Okay.
Oh, and that answers, or that asks another question, or it begs another question. If I didn't apply up until now for TER, can I apply? The answer is absolutely. So whereas initially, and again, don't let this commissioner lie to the public and say there never was a cutoff period. The cutoff period was always the 30th of April until such time as they removed that cutoff period. So now there is no cutoff period. Now the bottom line is you can apply any stage between now and even after lockdown has ended retroactively for the period that there was a layoff in your business, a temporary layoff in your business.
Well, I was one of the lucky ones that did get paid, and I was able to pay my employers. So, but
can I ask this? Did you get paid what you were expecting to be paid?
According to my accountant's calculations, what they calculated, because I did the submission myself, I did the whole CSV, the whole thing. But then they got some calculator form, and what she calculated, but was less to receive, and I received more. But she didn't work on a 35-day.
Okay, so that's important. Just remember, ladies and gentlemen, when you get paid out at the end of April, you're not going to be paid out for 30 working days or 30 days. You will be paid for 35 days because remember, the lockdown started, I think, on the 27th or the 26th of March. So you will be paid for those extra 5 days. All right, fantastic. Well, thank you, everybody. It was fun, and we'll definitely have to do this again.
Thanks, Ava.
Bye-bye.